Welcome to S&C's Critical Insights. I'm Annie Ostrager, a partner in the firm's litigation group, one of the co-heads of our employment law group, and a member of our criminal defense and investigations group. Joining me today from our DC office, although happily sitting here in New York with me today, is my partner, Camille Shields, who's also a partner in our litigation group and a member of our criminal defense and investigations group and a former prosecutor.
Well, thank you, Annie. It's lovely to be sitting with you. Today, we're going to discuss developments with respect to False Claims Act cases, especially in light of the recent focus on these types of cases in the current administration. So we'll begin by providing a brief overview of the False Claims Act, or FCA. Next, we're going to turn to what we think are potential uses of the FCA in the current environment. And then we'll wrap up by discussing how use of the FCA might expand in the future. In particular, given the administration's stated prosecutorial focus on fraud, waste, and abuse. So Annie, if you wouldn't mind kicking us off with some background about the FCA, I think that would help frame our discussion.
Yes, I'd be happy to do that. And I think this is a very timely topic for everything that's going on right now. For decades, the FCA has been the government's primary mechanism for combating fraud or potential fraud in government programs. Under the FCA, entities found to have received money from or avoided paying money to the government by knowingly making false statements or certifications can be liable for significant financial penalties. This is because the FCA provides for civil penalties, treble damages, and where applicable, and we'll talk about this more, whistleblower attorneys' fees. Camille, you and I have spoken about the role of whistleblowers in government enforcement matters on a prior S&C Insights podcast, but as a reminder, under the FCA, these cases can start with a complaint by either the Justice Department or a private whistleblower, and if an action is commenced by a whistleblower, known in this context as a qui tam action, the relator essentially stands in the shoes of the government. The relator's complaint will be under seal unless and until the DOJ decides to intervene. If that happens, it takes the place of the relator and prosecutes the case. Depending on the whistleblower's contribution to the matter, that individual or individuals can get up to as much as 30% of the amount recovered by DOJ. Last year, the DOJ filed 423 False Claims Act cases. Whistleblowers filed 979 qui tam actions, which is the highest ever in a single year. And the government and whistleblowers were party to 558 settlements. So significant activity in this space. And as we previewed at the outset, likely to increase in focus as various areas are scrutinized going forward in the current administration. This is consistent with, though slightly higher than the trajectory of these types of matters over the last few years. Over the last decade, the DOJ has recovered over $2 billion in these kinds of cases annually. Broadly, False Claims Act enforcement actions last year centered on 4 areas: fraud related to healthcare, military procurement, the pandemic, and cybersecurity. Toward the end of the Biden administration, the DOJ announced 2 notable settlements that will flag, given that the defendants were a healthcare company and a defense contractor, where there has been significant focus in this space. The first was Teva Pharmaceuticals, which is the largest generic drug manufacturer in the company. And in that case, agreed to pay $425 million to resolve allegations that it violated the False Claims Act by engaging in price fixing. The company also agreed to pay an additional $25 million to address claims that it conspired with other generic drug manufacturers and that the benefits received in connection with that scheme constituted illegal kickbacks. Then the second, which came just a couple days later, was a resolution Raytheon reached in which it agreed to pay $428 million to resolve allegations that it knowingly provided false cost and pricing data in negotiations with the Department of Defense related to government contracting and ultimately double billing on a weapons maintenance contract. Given the significant role of the False Claims Act in recovering funds related to fraud against the government, we expect and have already seen an uptick in the number of FCA-related matters that will be brought in this administration. Camille, now I'll turn it to you to dive into some of the recent activity we're seeing in this space.
Certainly, Annie. On January 21st, 2025, the president issued Executive Order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which prompted renewed discussion about the FCA. In particular, the executive order explicitly referenced the FCA by requiring that grant recipients agree to compliance in all respects with all applicable federal anti-discrimination laws that are material to the government's payment decisions for purposes of Section 3729B4. Now let's talk about why this actually matters. And the reason it matters is because there are certification provisions and termination provisions of this executive order. And what the certification provision states is that all federal contractors and grantees have to agree that compliance in all respects with applicable federal anti-discrimination laws is material to the government's payment decisions for purposes of the False Claims Act, and that it must certify that it doesn't operate any programs promoting DEI that violate applicable federal anti-discrimination laws. So in short, you agree that you are complying with federal laws and that that's material to the government or important to the government in deciding whether or not to give you funds. And then you have to certify that you don't operate programs that violate these kinds of laws. So notably, because there were a number of different concerns and issues raised with this, plaintiffs sued, and on February 21st, the District of Maryland issued a preliminary injunction that blocked the certification provision. However, the Fourth Circuit has since stayed that preliminary injunction, and that's pending the government's appeal. So what that means is that those certification provisions, that piece of the applicable executive order, remain in effect. In the April 15th order, Judge Kennelly held that the plaintiffs would likely be able to prove that the certification provision violates the First Amendment because it attempts to regulate grantees' speech outside of their federally funded programs. Further, Judge Kennelly found that the provision on its face makes clear that the counterparty must certify that it does not operate any program that promotes DEI, irrespective, meaning it doesn't matter, whether the program is actually federally funded. With respect to the termination provision, Judge Kennelly held that the plaintiff was likely to prevail in challenging the termination provision for violating its First Amendment rights because of the coercive, vague threat. This TRO, we want to make clear, is limited to the named plaintiff and any federal grantee through which the named plaintiff holds a subcontract or is a subrecipient of federal funds. So it's only with respect to Department of Labor grant recipients. Therefore, it's a lot narrower than what we've already been talking about with respect to the District of Maryland, where there was a nationwide injunction, but as noted, that nationwide injunction has been stayed.
I think that's right, Camille. And also, all of that litigation is against the backdrop of the memo issued by the DOJ, which sets out a clear focus and mandate to investigate, eliminate, and penalize what is referred to as illegal DEI and DEIA preferences, mandates, policies, programs, and activities in the private sector.
And Annie, we've spoken a bit about, obviously, these executive orders and some of the actions in court. I think it would be really helpful if you could share with us what you think, how the administration might use FCA. We've obviously already seen it with respect to DEI, but other applicable spaces.
Sure. So I think we are going to see use of this statute more broadly. Earlier this year, the Deputy Assistant Attorney General confirmed that DOJ will continue pursuing FCA-related enforcement of healthcare and pandemic fraud and cybersecurity compliance. In addition, the administration has added tariff and customs avoidance as an enforcement priority, and tariffs are a focal point of the policy agenda that we are seeing. And since the FCA does not require proof of specific intent to defraud, it could be a viable cause of action for tariff-related claims. And for more on this, you can read our colleagues' article in Bloomberg, Tom White and Andrew D. Philippus. New tariff environment poses big risk and opportunity under the FCA from mid last month. I think we'll also potentially see the government or private litigants using the FCA to enforce customs compliance by targeting entities that allegedly intentionally avoid paying money owed to the government, including customs duties. And the Deputy Assistant Attorney General also emphasized that the FCA is a powerful tool to use in combating illegal foreign trade practices. In addition, monetary incentives under the FCA could encourage more private litigants to report suspected FCA violations. And then, of course, there is the explicit reference, as you covered, to use of this statute in the DEI space. And we see that in some of the guidance that has come out in connection with the executive orders.
That's right, Annie. I think that what we really want to share is just that the False Claims Act and the use of the False Claims Act is really occurring in a number of different spaces. There are a number of different considerations. And given that it is a tool that's been wielded by numerous administrations, folks just want to be thoughtful, particularly federal contractors or other entities that obtain federal funds, about certifications they're making, representations, just because it is such an important arsenal, not only the Department of Justice, but other administrative agencies in their quiver. So because these actions have just these significant financial and reputational consequences, it's important for companies to look at and make sure that their policies and procedures are in compliance with applicable rules, that they're aware of any federal fundings, and that they're keeping track of the many changes that are being sparked by changing administrative policies in the space. So it's important for our clients to stay abreast on these issues. We have really interesting guidance out there. I have to give a plug for our colleagues. I thought the article on tariffs was excellent. And as always, we appreciate you listening to us on S&C Critical Insights. I hope to do this again with you, Annie, as these developments continue and we are monitoring the space and can work with our clients on structuring important guidance here.
Absolutely. Thanks, Camille. And thank you for listening to S&C Critical Insights. For more information about our practice, please visit us on the web at www.sulcrom.com.